Hi, Attorney Steve Vondran, and welcome back. We are talking in this video about real estate ethics hearings. This is very important. If you find yourself in a real estate ethics hearing in the state of California, very similar if you're in Arizona, probably very similar if you're in any other state. We're talking about the N.A.R. Code of Ethics. What's N.A.R? National Association of Realtor Code of Ethics. Okay, so if you get called in, we're licensed to practice law in California and Arizona. This video is going to help you succeed in your ethics hearing. Without further ado, let's head to the Attorney Steve Real Estate Whiteboard. Okay, so we are talking in this episode about ethics hearings. What happens a lot of times, you get involved in a transactional dispute. The parties are going crazy. You got interference with agency. You've got failure to get documents in writing. He said, she said. Everybody's pointing. Everybody's going crazy. Big commissions on the line, residential and commercial real estate, and sometimes business opportunities. And you don't know what to do. Somebody files a complaint, an arbitration oftentimes. You have realtors in the arbitrations fighting it out, duking it out. That's why we have our gloves here. Duking it out for our real estate commissions. And sometimes what often accompanies that is an ethics complaint, okay? So these are going to go to the association where the members are, the realtors are members and members of the association, and these are the kinds of things that can happen. So let's talk about it, okay? So we're trying to figure out some of the ways to win if you end up in the ethics case, okay? Process is very basic, as you can see by this rudimentary drawing. Complaint gets filed. Here's your complaint. You've got your N.A.R. Code of Ethics violations, okay? And I think we have 16 code sections and 17 with the duty to arbitrate. You got your 16. And so you're going to have one of your violations. You're going to have one or more, okay? Now, as a complaining party, make sure you have your grounds. Do not just be checking off boxes. We've seen people just going, oh yeah, he's violated every ethical rule in the book. No, don't do that. Go through, read them, or contact us, your real estate lawyers, to help you figure out what your actual ethical grounds are, okay? So you want to be there. You actually, one of the codes, I think it's section 15, says you have a duty to be accurate and not report people, make false charges against people. So take your time. You want to be accurate about the charges that you're leveling against someone else. Okay, so it's a serious deal because you're taking on somebody's reputation and their hard work. Only file these complaints if you really have the evidence, if you really have it, okay? So you're going to file your complaint there. There's your complaint. Some of the common grounds, I'm just going to give you a couple quick ones, and we're going to do some more videos on these so that you can really drill down onto what these different ethical rules means. They're very, they have a lot of meat to them. Article 1. Fiduciary duties, breaching your fiduciary duties. Article 2, concealment of a material fact. You always see this in a transaction. Oh, he didn't tell me this, she didn't tell me that, I don't know what's going on. They have to keep me informed in the loop and they're not. Concealment of material facts, Article 2. Article 3 is another popular one. Cooperation amongst brokers. What does that mean? You know, it's kind of a lot of different things. Cooperate, he didn't cooperate, they're not cooperating. So you see how these things can get. Article 9, failure to reduce your real estate documents to a writing. In a real estate transaction, as a real estate agent, as a broker, salesperson, you should always be documenting everything in writing. Everything to your client, to opposing parties. Get it in writing. Have those critical documents. Documents don't lie. People do. So if you get things in writing, you don't have to worry about the lying person, which we will talk about in a minute, okay? So Article 9, failure to get things in writing. Article 16 is another popular one, doing something inconsistent with exclusive representation. I represent this person, they came in and stole my client, didn't recognize and appreciate the agency relationship here, blew it all to heck. Sometimes these can raise questions about the tort of intentional interference with a prospective business advantage or inducing a breach of contract. Those are other videos. Stay tuned. Make sure you subscribe by clicking on our red V so you can get this information and materials to your desktop where it needs to be. Okay, so these are some of your common complaints in a Code of Ethics violation. These get filed with the board at your association. There will be a vetting committee that will look at this and say, is this Is there something here? Is this stupid? Is there not, you know? So there will be that little vetting process in here that I'll draw. If it's a valid complaint, if it looks like it has some teeth to it, then the other party will be invited to respond to the complaint. So often when you're responding to the complaint, you'll have a chance to disqualify different panel members. You'll see at some point during the process a list of panel members. You can vet them out, see if there's anything going on. One thing I like to do is look up the panel members and look them up on the BRE website. Google Vondran BRE lookup. We show you how to look that up if you don't know how, and see if they have any disciplinary measures on there, because maybe if they have disciplinary measures, maybe they shouldn't be on a board. I'm just throwing ideas out. Okay, so you have a response period. That's again where you're going to want to make sure you have counsel. These can be very serious. These can be reported to the BRE. These can be referred out if there's something criminal going on. These can be referred out to the Attorney General, local district attorney, depending on what you have going on. So this is a good time to get a lawyer involved, to say, help me, I have to defend this, or get a lawyer involved here, help me, I want to make sure I'm writing a complaint and not missing things. And so we have this back and forth process. There always is a chance to resolve your situation and see if the parties can come together and reach an agreement, withdraw their complaints, save everybody a lot of time and hassle. But let me tell you, when you get into these situations, the egos can be so elevated. The pressures, the intensities, the commission amounts. I mean, my professionalism versus yours. So these can become very, very contentious. Now, let's talk about the hearing. I'm going to give you what I call my top 5 tips. I'm going to give it to you as quick as I can. And then we're going to drill down in details on these. Proper planning. I call this the PLUK, by the way. PLUK. Okay? PLUK. Planning. Proper planning prevents poor performance. The 5 P's. I learned this back in baseball when I used to be a baseball player back in the days. Proper planning prevents poor performance. Say it with me. Proper planning prevents poor performance. So planning is critical. Your witnesses, your documents, get everything all lined up. Be ready to go in there with your timeline. You have a timeline of all the detailed facts of the case. You're ready to take it on. Okay, so be ready for that. Proper planning. Get your witnesses ready. Get them getting them to show up on time. Going through a dress rehearsal with them so they know what they're going to say. So you have it all orchestrated exactly how you're going to play this out. Liars, L. PLUK, L, liars. Be prepared. A lot of people tell me, I can't believe this person was lying. I said, well, welcome to my world. This is, the world where lots of people lie. Money's on the line. Reputations are on the line. People are going to lie. Expect it and be prepared for that. How do you be prepared? You have the rebuttal evidence. You have a witness that's going to say that's not true. You have a document you're going to wiggle that up and say this is simply not true. And you're going to have your document, okay? Don't shake it that hard. You may scare somebody. But liars, be prepared for the liars. Don't get taken off guard. Don't get offended by it. It's going to happen, okay? Objections, 3, PLUK, O. Be prepared to object. The only chance you have, if you lose the case, the only chance you will have to appeal is what we call a due process appeal. And that's where you have to have due process grounds. Now, if you're not objecting during the hearing, if you're not objecting and making those objections, let me object and get this on the record. It's very important. I'm not being allowed to get my evidence in. I'm not being allowed to present this. The panel should not hear this evidence. It's completely prejudicial and it has no bearing on this. Different things that you can try to say. So objections, get it on the record. That way if you lose, you can call up and say, Attorney Steve, I lost. I don't know what happened. The whole thing blew up. They were lying. I wasn't prepared. I didn't know this was going to happen. So be prepared and get those objections on the record. Be respectful. Remember, the panel is a volunteer panel. They are not paid professionals. They're not doing this 5 days a week. They're not going to be here doing everything perfect. So you have to, if you feel something's not fair, just raise your hand and say, I would just like to say that this doesn't feel fair to me, and here's why. You have to be ready to own up and make those objections. PLUK, O, second O. Opening and closing. Be prepared to give a good opening and closing statement. Okay, some people like to waive it and say, well, I'll just waive it. I don't want to do it. It's, you know, it's everybody's looking at me and I'm nervous. Don't do it. Don't waive it. Don't be tempted. Okay, an opening is simple. The opening is going to say, this is what the evidence will show. The evidence will show I was the broker. The evidence will show I was procuring costs. The evidence will show I did not abandon the client. The evidence will show I'm entitled to the commission. The evidence will show the MLS said it was a 3% commission. Now they want to pay me 2%. So the opening is just, this is what the evidence is going to show. This is what the case is about. This is why I'm entitled to justice. Or this is why they violated the N.A.R. Code of Ethics. Okay, this is what they did. They violated 1. They violated 3. They violated 9. Remember, the complaining party in an ethics complaint has to prove their case by clear and convincing evidence. If you got that, you're a superstar, by the way. Clear and convincing evidence. Clear and convincing evidence. Now that's higher. The normal burden of proof in a civil case is preponderance of the evidence, more likely than not. In a ethics hearing, it's clear and convincing. That's a very high standard. It's the same standard that we have to show fraud, punitive damages in the state of California. So it's a higher standard. You're expected to have more solid evidence, you know. Don't just sling mud. Make sure it's a nice solid brownie, you know what I mean? So have the opening and then the closing. The closing is the opposite. It's basically, here's what the evidence showed. I told you it would and it did. Here's what the evidence showed, this and that, and I told you that. Here's what the evidence showed, this, that, and I'll tell you that. This is not applicable. This is not applicable. This is not applicable. They did not carry their burden of proof. And finish with the statement like, you know, justice demands this. Here's what I suggest. 1, 2, 3. Dismiss these charges. There should be no fines and fees. There should be no this, no that. So be prepared to make those golden arguments while you're on the spot, and that will be a real nice presentation. Pluke, K. Final one, key point summary. Okay, key point summary. This is a 1 to 2 page summary. You are not getting fancy. You're not writing 1,000 words all over the pages. You're going to write bullet points, 5, 10, 7. Don't go more than 10. It's going to get crazy. 10 or less. I would put 5 to 7 would be my goal. Key points. Here's why you should find in my favor. Key points. Because that panel is, like I said, they're busy. Your dispute probably took 6 months, 3 months to wind its way through. And now you're trying to cram all these facts and on 3 panel members, volunteers, that are out running their own businesses. And you're cramming all this on their plate, telling them, you know, so give them a key point summary, something they can hang their hat on. Something they can hang their hat on when they're going to make a decision, okay? So give them the key point summary, something they can take back with them. Nice, short, concise bullet points, okay? Couple other minor points. Remember, in these proceedings, there's a duty of confidentiality. This comes up quite often, duty of confidentiality. Don't run around blabbing to all your friends about, I'm in arbitration, you know, I'm going to teach this person a lesson. I got him on Article 1, 3, 9, 5, and 7. You know, no, settle down. Duty of confidentiality, you get yourself into trouble by running around and blabbing, okay? Subpoenas, some people ask, well, can I subpoena all these witnesses? Not in an ethics hearing, no you cannot. So no subpoena power, ethics hearing. Finally, after the hearing, what's going to happen? You're going to get a decision and what we call FOF, finding of facts. This is what we believe, this is what we found, this is what the evidence showed. These are our recommendations and our decisions, okay? So that's what you're going to have. Again, at the end, if you're not happy, if you're hit with violations, you're not happy, you still don't believe. You could be hit with a fine up to $15,000, by the way. And you could have your picture published in the C.A.R database, and it could be shared with local associations. It's a whole nother thing. We'll talk about, I think we have a blog on that, about something about the mugshots with the C.A.R. So if you want to Google Vondran mugshots C.A.R, you'll probably find my blog. But you have a due process appeal, and again, these are tape recorded. You're going to get a copy of the tapes, but when you go back, you better have those objections. You better have those objections on there that you can point to, or you're going to say, well, why weren't you objecting then? They're going to help you. Not to say you have to have them, but for my purposes, you have to have them. Okay, so you have the due process appeal, and that's basically the basic overview. Okay, so what else? I think that's about it. Some people will ask, I've got this, some of the possible disciplinary things that could happen with the association. The association does not have the power to revoke your real estate license. It cannot revoke it, suspend it, restrict it. Those are things the BRE can do. But as I mentioned, they can refer you to the BRE. That is a possibility. Okay, you can be fined. You can have your membership, association membership suspended. Education, a C.A.R online ethics class. I'm reading off the thing here. A fine up to $15,000. Reprimand. A letter of reprimand placed in your file. A warning letter placed in your file. These are kinds of things. Expulsion from the association or from the MLS. Okay. So these are some of the basic things to keep in mind if you need help in an ethics hearing. Sometimes the pro standards people will tell you, oh, you don't need a lawyer, you don't need a lawyer. It's true, you don't need a lawyer. However, these are very important matters. This is your reputation on the line, and with the mugshots that you may be forced to take, I could read it down here, discipline subject to publication. You don't want to be in those shoes. So you don't want to get sandbagged and blindsided by these things coming your way. This is the general process. If you need more information, brokercounsel.com is where you want to go. This is Attorney Steve, the real estate lawyer. If you need some help, we're happy to help you. We do arbitrations, accusations, investigations, subpoena response, all kinds of things. So you need some help with real estate law, brokercounsel.com. We appreciate you watching this video. Feel free to share this video on your social media networks, and we look forward to working with you. Have a great day now. We'll see you again.